Hi, this is Cora Stack here. I'm on your side. I'm looking at the protective disclosures legislation again, and I have a lot to do here. I might have. There's a few corrections in terms of my research, and I have to look at it again. So there's a few issues that I have to correct. It's just in particular with regard to emissions, but the key point is it seems to me that the commissioner, if a report about emissions is directed to the commissioner, he does not have the power to transfer that matter to a court. That to me is a major flaw in the design, given the what emissions represent in the whole protective disclosures, in all of that. So in terms of wrongdoing, the definition of wrongdoing, so that's a major issue there. Yeah. So the four major barriers facing whistleblowers under Ireland's protective disclosures regime. Ireland's protective disclosures legislation appears in paper. This is what I'm seeing, rights on paper, but no rights in practice. Is this workable? Should we be looking at what's workable, what isn't? Ireland's protective disclosures legislation appears on paper, and why isn't it workable? Why isn't it workable? Who's causing all the obstructions to it being workable? That's another question. Ireland's protection disclosures legislation appears on paper to offer strong protection to whistleblowers. I mean, once it appears in paper, it will pass everything, won't it? Everyone will say, just look at it, it looks, but will they do the sort of analysis? However, when the legislation examined in practice, four major barriers become visible. These barriers raise a fundamental question. Does the present system genuinely deliver accountability? That's a big word, isn't it? Accountability, particularly for an ordinary worker who has no legal representation. That, let's face it, is the majority. I mean, barrier one, the new prima-facie evidence gateway. Now, this wasn't in the previous act. The question is, how did it appear in the new act? And it would be interesting to know how many other countries have this new prima-facie evidence. Was it part of the directive of the European Act? Or the European Directive, sorry, was that an insistence, or did it just appear in the Irish, as a gateway, allegedly? So I'd be interested in knowing that. Anybody having any knowledge on that, please put it in the comments. So under Section 5.8 of the original Protective Disclosures Act 2014, where legal proceedings raised an issue about whether a disclosure was protected, the disclosure was this was one of the most powerful provisions of the Act, which seems to have been removed from the new Act. A disclosure was protected. The disclosure was presumed to be protected unless the contrary was proven, and that was means in proceedings by a court. The original Act did not contain the present administrative gateway requiring the reporting person's disclosure to pass the preliminary prima facie assessment before receiving substantive follow-up. That's very significant, because that's subject to manipulation. I'm not saying in every case, but it is subject to manipulation. The 2022 legislation provided a new stage. A designated person now decides whether there is a prima facie evidence that relevant wrongdoing may have occurred, as I've mentioned in the previous, but I didn't realise, I had to check that it wasn't in the first version of the Act in 2014. Where that person decides, and I knew it anyway, it wasn't there, but I had to check it again. Where that person decides there is not the protective, there is not sufficient evidence, and where are the guidelines for that, that bar, the protective disclosures procedure may be closed, or the matter may be redirected into another process, moved around, fragmented. This represents a major change in practical emphasis from presumed protection in proceedings to preliminary institutional gatekeeping before the original wrongdoing may ever be properly examined. So that's my first barrier. Barrier two, the institution may control the gateway. In an internal reporting process, the person making the prima facie decision may be appointed, employed, and paid by the institution whose conduct has been reported. The legislation describes the person as impartial, but impartiality is not the same as structural independence. An employee may depend upon the institution for salary, promotion, workload, professional standing, and continued employment. So that's a conflict of interest. I mean, you could understand how that could generate a major conflict of interest, or even fear in that person for siding with the reporting person, even though they're alleged or they're supposed to be assigned to be impartial. That person may reasonably fear career consequences if they make findings that expose serious wrongdoing, legal liability, or reputational damage within their own organisation. I mean, that's just human nature. The problem is not that every internal assessor will act improperly. The problem is that independence simply cannot be guaranteed where the decision maker remains institutionally and financially dependent upon the body affected by the decision. I mean, again, that's human nature. Outsourcing does not necessarily solve this problem. The institution may select, for example, an external firm, define its terms of reference, supply its evidence, and pay its fees. The external organisation may also provide other professional service to the institution. And if you were in a situation and you asked, we'll say, an external person, were they conflicted in other ways? Well, do you think you'll get an answer? Without mandatory disclosure, what if you don't get an answer? What does that tell you? Without mandatory disclosure of these relationships, firm conflict rules, independent appointment, and automatic recusal, externalisation may merely recruit institutional control rather than remove it. And even the person that's assigned externally, where there is conflict of interest, in other parts of the external body. Sure, I mean, that person is under the same whip, if you like. Barrier 3, you'd feel sorry for them. Barrier 3, no direct route to a court determination. This now to me is huge. The legislation continues to recognise, this is where I had a slight issue here. Maybe my research was not as clear as it should be here as I'm investigating this more. The legislation continues to recognise certain acts of omissions as possible relevant wrongdoing. However, recognition in the statutory definition does not give the whistleblower a direct publicly funded route to obtain a judicial determination that an act of omission have occurred. And this is where I was caught I went to the commissioner to ask for that relief, not realising that he hadn't the power to give it when I sought a constitutional review of the issues raised in my constitutional review. So I've had to take on all of that pressure myself. And I feel that's a failure of accountability. The Office of a huge reduction in the rights of redress of whistleblowers. The Office of the Protective Disclosures Commissioner does not have a general power to transmit a disclosure to a court, so that the court can investigate and determine the underlying wrongdoing. Courts are not ordinary recipients under the Commissioner's statutory transmission structure. I mean, that was by design, in my opinion. The Commissioner normally transmits reports to a prescribed person or another suitable person considered competent to provide follow-up. Therefore, a reporting person who requires a judicial determination may have to identify a separate legal cause of action, commence proceedings personally, and bear the initial financial, which I had to do, a huge amount of money, which I didn't have. I mean, it just broke me, the work that went into all of this when I had no very little legal, nobody would support me. I mean, no barrister, solicitor, and I was told, because they're all, allegedly being paid by the state. Not all, but a huge amount of them are dependent on the state for fees, and they'd be afraid. Again, it's the same thing. I mean, it's not that they're bad people or anything, but they'd say, well, if I side against the state, I could lose my livelihood. I mean, that's just human nature. Again, it's understandable. The institution accused of wrongdoing is not required automatically to pay for that judicial determination. And that's the opposite, it seems to me, as to the rights that were in the initial act. Even where the whistleblower, and that is a failure of rights of redress or of accountability, even where the whistleblower ultimately succeeds, recovery of legal costs may be uncertain, delayed, or unavailable, particularly in WRC proceedings, where parties generally bear their own representation costs. I mean, this is a huge issue for people going to the WRC. Who pays their costs? This creates a profound gap between recognising an omission in law and making that omission independently enforceable in practice. Barrier 4, the Commissioner cannot guarantee institutional. This is a huge issue. I mean, again, this is by design, in my opinion. I mean, who designed this crazy act? Who's behind this crazy design? I mean, has any politician answered that question? I mean, surely it wasn't the ministers in question, or have they all disappeared from the shores, the flight of the Isles? But I mean, surely they had solicitors behind the scenes, in major legal firms doing all of this tactics. I mean, they wouldn't have come up with all this ingenuity to block whistleblowers by themselves, in my opinion. Sure, it's all you can see. And did that act go to the Supreme Court? Was that appalling reduction in the rights of address, was that referred to the Supreme Court for determination by the President at the time? Or was it all kept inside the closed loop? Allegedly. I haven't checked that now, but it seems that it wasn't referred to the Supreme Court. And there's such a reduction in the rights of redress, you'd imagine that it would be one act that should have been referred to the Supreme Court in the previous administration. So perhaps that's why we need to stop this closed circle. Allegedly. This is all alleged. The principle statutory, but if there was any act that should have been referred to the Supreme Court in the last 7 or 14 years, surely it was the Whistleblowing Act, the new Whistleblowing 2000. That's the one act that should have been referred to the Supreme Court. Now, there's no evidence that it has been referred to the Supreme Court, so we can only assume, because there's no evidence that it was not. So this is a major problem for accountability, and why it's so important that the President is completely independent of the government, particularly with regard to what has happened here, allegedly, if the amended act was not referred to the Supreme Court to look at it for the many problems that I can see in it. So the Commissioner cannot guarantee institutional accountability after transition, but I haven't had it. Nobody has said to me that it was referred to the Supreme Court, and